Good evening. I'm Josh Dunn, the Executive Director of the Institute of American Civics, and I'm pleased to welcome you to tonight's debate. Our distinguished guests, Vikram Amar and Chuck Cooper, will explore the question: are persons born in the U.S. or temporarily or illegally present parents U.S. Citizens by birthright under the 14th Amendment? Before they address this timely and compelling topic, I would like to share more about the IAC and our mission. The IAC aims to strengthen civic education and participation while reviving thoughtfulness, civility, and respect for opposing viewpoints. Today's debate is just one example of the varied programming the Institute is engaged in to achieve this mission. In addition to public lectures and debates, we also provide education programs for K through 12 students and teachers, deliver civics curricula to UT students, and promote civic engagement across Tennessee. Please visit our website, civics.utk.edu, to learn more. Tonight, we're excited to partner with the Steamboat Institute for another compelling debate. The Steamboat Institute has been a national leader in bringing spirited but civil debates on issues of constitutional, political, and economic importance to campuses across America. As a reminder, at the University of Tennessee, civility is an expectation of our audiences too. It is now my privilege to introduce Hadley Heath Manning, the Executive Vice President of the Steamboat Institute, where she oversees strategic vision, programs, and operations. She's a respected policy expert who's called upon frequently by national media for her commentary. Please join me in welcoming Hadley Heath Manning.
Good evening. Thank you, Josh, for such a warm welcome to the University of Tennessee. I was raised a Vols fan. I've been to UT many times, mostly to go to Neyland Stadium to watch the Volunteers play football. And I'm glad to be here with all of you tonight for a different type of contest, a matchup of two of the country's top legal minds on the topic of birthright citizenship. Tonight's debate is the fourth stop in the spring 2025 edition of our Steamboat Institute Campus Liberty Tour. We are visiting 5 campuses this spring with a unique debate topic at each location. You can view the full debate schedule as well as speakers and topics on our website at steamboatinstitute.org. You can also watch all of our previous debates on our YouTube channel. As with all of our debates, the focus is on civility and on showing students and all who attend how to think, not what to think. As a nonprofit, nonpartisan organization, Steamboat Institute relies on the support of many generous individuals and foundations to bring programs such as tonight's debate to audiences across the country. I'd like to extend a special thank you to the Adolph Coors Foundation, the Diana Davis Spencer Foundation, the Linda and Harry Bradley Foundation, the Jack Roth Charitable Foundation, Tina Snyder Foundation, and Bruce and Marcy Benson for their support, which is allowing us to expand this program to more campuses across America. Now, on to tonight's program. The resolution tonight: are persons born in the U.S. to temporarily or illegally present parents U.S. citizens by birthright under the 14th Amendment? We invite all of our audience members now to respond to this question: agree, disagree, or undecided using the QR codes that have been provided to you. We will then ask you again after the debate is over to see if your opinions have changed. So please take a moment to vote with your phones to make the polling as representative of our audience as possible. For those of you who are watching on the live stream, there should be a link in the chat so that you can also participate in the poll. And now it's my great pleasure to introduce our speakers and our moderator for this evening. So let's bring these gentlemen to the stage. Arguing the affirmative tonight is Vikram Amar. Vikram Amar returned to UC Davis as a distinguished professor of law in 2023 after serving as the dean and the Iwan Foundation Professor of Law at the University of Illinois, Urbana-Champaign College of Law since 2015. Directly before that, he was a professor and the Senior Associate Dean for Academic Affairs at King Hall from 2008 to 2015. Mr. Amar has also taught law at Berkeley School of Law, Hastings College of Law, and UCLA School of Law. Mr. Amar is one of the most eminent and frequently cited authorities in constitutional law, federal court, and civil procedure. He has produced several books and more than 60 articles in leading law reviews. He earned his bachelor's degree from UC Berkeley and his JD from Yale Law School. Arguing the negative tonight is Chuck Cooper. Chuck Cooper is a founding member and the chairman of Cooper and Kirk PLLC, which, according to Above the Law magazine, is one of the nation's leading litigation boutiques. The National Law Journal wrote that Mr. Cooper's brilliant legal career has so far spanned 5 decades and thrust Cooper into the spotlight in some of the most historic moments of the country's modern history. He has argued 9 cases before the Supreme Court and scores of appeals before each of the 13 federal courts of appeals and several state Supreme Courts. Mr. Cooper has published scores of articles and has spoken extensively on constitutional and legal policy topics. He has appeared before congressional committees on 24 occasions, testifying as an expert on a wide variety of legal issues, including the topic of tonight's debate. And please don't boo this part, but Mr. Cooper earned his BA and his JD from the University of Alabama. Our moderator tonight is Philip Wegmann. Mr. Wegmann is a senior Tony Blankley Fellow at the Steamboat Institute and a national political reporter who covers the White House for Real Clear Politics, a post he's held since 2019. He has reported on 2 presidencies, and 2 presidents have yelled at him. On the White House beat, Mr. Wickman represents RCP at the daily briefing, where his questions during the pandemic, the Afghanistan withdrawal, and the border crisis regularly broke news. And Phil, I know if you can navigate Washington, D.C. traffic on your motorcycle, then surely you can help us navigate tonight's complex debate topic. Ladies and gentlemen, please join me in welcoming our debaters and our moderator as I turn things over to Phil. Thank you.
Well, thank you, Hadley. I'm Philip Wegmann, your moderator, and that's all you need to know about me. Vikram Amar is to my left, and Charles Cooper is to my far left. And the debate directly before us, well, that has to do with the meaning of the 14th Amendment, the scope of U.S. citizenship, and the very nature of our American system of government. Just to jog your memory, as we are about to begin, Section 1 of the 14th Amendment defines citizenship in this way: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That is the law of the land. How could that be at all controversial? The resolution, again, I'm going to read it here, is resolved. Persons born in the U.S. to temporarily or illegally present parents are U.S. citizens by birthright under the 14th Amendment. Again, Amar will argue the affirmative, Cooper the negative. And it's a timely question, and one that will be before the Supreme Court in one way or the other in just a few weeks. President Trump began his second term by challenging a century of legal consensus with a sweeping executive order to end birthright citizenship for those children who do not have at least one parent who is a U.S. citizen or a legal permanent resident. The court will soon hear oral arguments, but tonight you vote. Again, Vikram is arguing the affirmative that birthright citizenship should continue as it has for over a century, even for those whose parents are here illegally. Charles will argue the negative. So pull out your phone if you haven't already, scan the QR code, and enter your pre debate opinions now. And now we're ready for the opening statements. Go ahead.
First of all, I want to thank the organizers of the debate and Chuck Cooper and Philip Wegmann for being here. It's really my honor to be at this event. Let me start by kind of highlighting that the question I'm going to address is not really should birthright citizenship attached to people born here to uh, temporarily or illegally present parents. It's whether it does or not. So the Constitution has meaning. It is what it is. I think there are credible arguments for changing the Constitution if we don't like what it means. But I'm not a fan of making up constitutional law just to suit whatever policy objectives we might have. I think the court gets into a lot of problems when it does that. And I think what makes this question relatively straightforward and explains the consensus that Philip referred to is that all of the mainstream ways that we have of interpreting the Constitution, the text, the history, the structure, and judicial precedent, they all kind of line up here. So I think that's why. Um, the consensus is held for so long. It's why the vast majority of constitutional scholars across the spectrum, I should add, agree that the words mean is pretty much what they say they mean, straightforwardly. And you have, very leading conservative scholars like Michael McConnell, who was the leading constitutional scholar of his generation, Steve Calabrese from Northwestern, the founder of the Federalist Society. These folks read the Constitution the same way I'm going to read it, but we're going to let you decide for yourself. So let's start, if we will, with the text of the Constitution. Why is this not working now? Daniel, do we know why the slides aren't working? There we go. Okay, let's back it up. Okay, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and the states in which they reside. All right, let's break that down. It's got two requirements: persons born in the United States and subject to the jurisdiction of the United States. Notice that this amendment, passed after the Civil War, says nothing about the parents of the persons born. Persons born in the United States who are subject to the jurisdiction are citizens. It's very straightforward and simple. And that has been interpreted to mean, and I think this is correct, that if you're born on land that flies a US flag, where the US government is in control and subjects you to its laws and punishes you if you violate those laws, if you are born in that place, you are a citizen. This is a very different kind of system than they have in Europe, where it matters not where you are born, but to whom you are born. That's why Europe has titles of nobility and royalty. America threw off all that. This is in the English tradition of birthright citizenship based on the law of the soil. In, in England, you are a subject of Britain if you were born anywhere controlled by Britain. So this common law rule from England that persons born within the lineage of the Crown of England were natural born subjects without reference to the status or the condition of their parents. That's what we inherited. That's what we brought over. Even before the 14th Amendment, this was the law of the land of the United States. Now, we have to decide what it means to be born in the United States. There were exceptions. If you were born in an embassy, or you to a family that lives in the embassy, and we basically fictively say you were born there, even if you were born at the hospital down the street, or if you're born on an Indian reservation, or off the reservation, but we fictively say you were born on that territory. That's not territory in the United States, and that's not territory that is subject to the power of the United States. But everybody else born in the United States is considered a citizen by virtue of birth. Why? Because they have to obey the laws of the United States, regardless of whether they're here temporarily, regardless of whether they're here with allegiance and fidelity, regardless of whether they came lawfully. They are subject to the jurisdiction of the United States. That's the way Chief Justice John Marshall construed it in 1812. It's the way the founders of the 14th Amendment construed it. And it's really not that much more complicated. It goes back to the English common law. This is a very well-known case from New York in 1844. Then we look at the lead up to the Civil War. This is the Attorney General of the United States under Abraham Lincoln. And he basically says, and you can read it for yourself, children born in the United States of alien, that is non-citizen parents, are automatically citizens without being naturalized. It's as simple as that, he says. And he cites to this opinion written in 1844, the one I just showed you, as emblematic of this deep tradition that has extended from England to here. And then he brackets the exceptions I already mentioned. If you are born to parents who are ambassadors, or parents who are Native Americans who are not fully subject to the power of the United States, because they're like a separate sovereign, a separate country, then the rule doesn't apply. But there are only three exceptions to the rule. If you're born to ambassadors who are not subject to the jurisdiction of the United States, they have diplomatic immunity. Indians who have not diplomatic immunity, but sovereign immunity based on treaties and other things. And then an exception that happily we haven't had to use in the United States, if you have occupying armies, not invading persons, but occupying military forces that control part of your territory, as was true in England over history, then England wasn't really exercising jurisdiction over those territories. And so if you were born at that point, you also weren't a citizen. But absent those three exceptions, the rule is very straightforward. And during the discussion of the Section 1, people were asked, the people who proposed it, do you mean that Chinese children get to be citizens? They said yes. Gypsy children get to be citizens, even though gypsies and Chinese parents could never become citizens. The children who were born here were automatically. And then after the Civil War and after the 14th Amendment was adopted, we have this statement from the US Secretary of State. 14th Amendment is simply an affirmance of the common law of England to this effect. Why is it not working? Oh, okay. Um, we can pass by this. Then there's one big Supreme Court case, and we'll talk about it more, but I'll leave it at this right now. It's called Wong Kim Ark, an 1898 case where a child of Chinese foreigners, aliens living in California, were claimed to be a citizen, and the U.S. Supreme Court had little trouble affirming that, and you can read it for yourself. Again, by the common law of England, every person born here is a citizen. It doesn't matter whether the parents are settled here or temporarily sojourning. That is, on a visit. Being born here is good enough. So with that, let me just step down and cede the podium to my my friend and colleague Chuck.
Well, good evening, ladies and gentlemen. And I too want to thank the sponsors of this evening's debate. And thank you, Mr. Moderator and Professor Amar. Always an honor to be with you, share a podium with you. The debate tonight is over the meaning of the words subject to the jurisdiction thereof. And the debate therefore boils down to a choice between two alternatives. Does it mean, as Professor Amar argues and others, subject simply to the laws of the United States, as is virtually everyone on United States soil, including those who are here illegally or temporarily? Or does jurisdiction mean, as the author of the clause, Senator Jacob Howard, explained to the Senate in the 39th Congress, the full and complete jurisdiction of the United States, requiring the allegiance that comes from a commitment to make the United States one's permanent and lawful domicile, a requirement that neither an illegal alien nor a foreign sojourner can satisfy. I think it means what Senator Howard said it means. Start with the text. First, if subject to the jurisdiction of the United States means nothing more than subject to the duty to obey our laws, then why did the framers use such a strange way to say it? Why didn't they just say subject to the laws of the United States? That would have been easy enough. That formulation already appears 2 times in the Constitution. The framers didn't use those words, I submit, because that is not what they thought the clause should mean. What they did mean is strongly suggested by the text guaranteeing the birthright citizenship of the United States are also citizens of the state wherein they reside. In what rational sense does a child reside in the state where the child was born when the parent's sole purpose for visiting the United States was to secure birthright citizenship for their child? Obviously, neither the sojourning foreign parents nor their nor their newborn reside in the United States, at least not if that term means something more fixed and more permanent than a short stay in a hotel room. And it does mean more than that. It means the place where one lives and makes one's home, where one is domiciled. As Justice Joseph Story explained, by residence in the Constitution is to be understood a permanent domicile in the United States. In turn, the domicile of a person, said Justice Story, is where he has his true, fixed, and permanent home, and to which, whenever he is absent, he has the intention of returning. A foreigner visiting this country temporarily, by definition, does not permanently reside here, nor does an illegal alien who is prohibited by law from residing in any state. The legislative history of the Citizenship Clause confirms this interpretation. That history is inextricably bound up with the Civil Rights Act of 1866, which was debated and passed by the 39th Congress just 2 months before they passed the 14th Amendment and the Citizenship Clause. The act contained a citizenship provision establishing that, I'm quoting, all persons born in the United States and not subject to any foreign power, not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. The phrase not subject to any foreign power precluded on its face the birthright citizenship of children of temporary foreign visitors and illegal aliens, because the child's foreign parents would continue to owe their permanent and abiding allegiance to a foreign power, their home country, where they and their children were permanently domiciled. The Act's legislative history confirms this understanding of the 1866 provision. The provision was authored and introduced by Senator Lyman Trumbull, who announced in his opening remarks the meaning of the provision is to make citizens of everybody born in the United States who owe allegiance to the United States. He admitted that he had difficulty in framing the amendment, he said, explaining that he initially thought the provision should state that all persons born in the United States and owing allegiance thereto are hereby declared to be citizens. But, he continued, upon investigation, it was found that a sort of allegiance was due to the country from persons temporarily resident in it, whom we would have no right to make citizens. So the author of the citizenship provision said straight up that the act was intended to exclude from birthright citizenship a child born to foreign parents while temporarily visiting the United States. And the words not subject to any foreign power were chosen to make that clear. This understanding of the provision's meaning was not at all controversial. No one, proponent or opponent, objected or otherwise expressed the view that an American born child of foreign temporary visitors should be entitled to American citizenship at birth. Brings us to the 14th Amendment. And when the 14th Amendment was taken up in the Senate, Senator Howard moved to add the Citizenship Clause, Section 1. The language of the proposed clause differed from that of the Civil Rights Act. The phrase, not subject to any foreign power, excluding Indians not taxed, was replaced with the phrase, subject to the jurisdiction thereof, the language that is so controversial today. But Senators Howard and Trumbull, the authors of both provisions, emphasized that the change in language was not intended to change the scope of birthright citizenship under the Civil Rights Act, explaining that the new language is simply declaratory of the law of the land already, and that the object to be arrived at is the same. Rather, the language was changed to address concerns relating to Native Americans. And the clause's proponents made clear that the clause drew a sharp distinction between the citizenship rights of Indians belonging to tribes, as they put it, which the United States had always regarded as foreign powers, and Indians who had left their tribal reservations and had domiciled and assimilated in the American body politic. The distinction was based on allegiance. Senator Trumbull stated emphatically, what do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. And tribal Indians on reservations are not, he said, in any sense subject to the complete jurisdiction of the United States, because it cannot be said of any Indian who owes allegiance to some other government that he is subject to the jurisdiction of the United States. Senator Howard reiterated Trumbull's point. The word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction on the part of the United States. That is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States now. No one who spoke in the Senate debate suggested that American born children of temporarily visiting foreigners would or should become American citizens. The bottom line of the clause's history was well put by Chief Justice Fuller and Justice Harlan in their dissenting opinion in Wong Kim Ark. They said this: the 1866 Civil Rights Act was passed and the 14th Amendment proposed by the same Congress, and it is not open to reasonable doubt that the words subject to jurisdiction thereof in the amendment were used as synonymous with the words and not subject to any foreign power. So I believe it follows from this history and this language that illegal aliens and aliens temporarily present in the United States are not subject to the jurisdiction of the United States. Thank you.
We will move on to the question and answer portion of tonight's debate. As a reminder, if you have questions, submit them now using the QR code that you used just a moment ago to vote. So, Charles, I want to start with you. You touched on this in your congressional testimony and then again tonight, but take us back to postbellum America to start. What in the 14th Amendment specifically made former slaves U.S. citizens and overturned Dred Scott if the subject to the jurisdiction thereof clause implies an allegiance for protection social compact? Because certainly those slaves did not consent to being brought here in the first place. And then the slaves who were brought illegally after the international slave trade was outlawed, they didn't either. How could they consent so that they could provide allegiance?
The slaves, whether brought here involuntarily, either before the slave trade was outlawed in 1808 or after the slave trade was outlawed in 1808, again, were brought here voluntarily, involuntarily. They owed no allegiance to any sovereign other than the United States, and that was that was the fundamental point. It was that they were born in the United States. They were subject to the jurisdiction, the complete jurisdiction of the United States, owing no allegiance to any foreign power, and only owing allegiance, such as it was, to the United States. So they were well within the intendment of the 14th Amendment Citizenship Clause. Now, the slaves that were brought here involuntarily after the trade in slaves was outlawed. They were not committing a crime by being brought in here. It was only the captors and the people involved in the slave trade who were committing a crime. And so the idea, which has been advanced, that they were the illegal aliens of their day was just not right. There surely is a fundamental difference between people brought uh, in chains to the United States and people who actually affirmatively and deliberately violate the law themselves to come into the United States as illegal aliens.
Vikram, do you find that persuasive?
I don't. So let's just take a step back again. If the straightforward text, and I know Chuck says, why did they use the word jurisdiction instead of laws? Because jurisdiction means subject to the legal power. That's a legal term. The Constitution is full of legal terms. There's nothing kind of awkward or bizarre about them using that term, subject to the jurisdiction thereof. Chuck and I actually do agree that the 1866 Act and Section 1 are largely, if not entirely, kind of synonymous. um, but I don't read the 1866 Act the way he does, nor do most scholars. Subject to another foreign power in the 1866 Act is probably best read to mean subject to exclusive power by another country. So if you are not subject to the United States jurisdiction, but only to that of another country, like diplomats, like Indians, like people born in areas that are occupied, then the offspring are not going to be citizens. But this idea that citizenship is all about allegiance, and if your parents aren't kind of pledged their allegiance to the United States, and if they have some allegiance to another country, then the child is not going to be a natural born citizen. That fails for so many reasons. First of all, again, the text of the Constitution doesn't say anything about the parents. It's about the person who is born. The other side wants to read the amendment as saying any person born to parents, but any person born in the United States to parents who, by acts of allegiance and permanence, are subject to the jurisdiction thereof, are citizens of the United States. It doesn't just any person born in the United States and subject to the laws thereof or the jurisdiction thereof. And John Marshall said jurisdiction means laws in 1812, no different. But the allegiance theory cuts too far. Why? Because permanent resident aliens are citizens of the other country, not the US. Their allegiance is to that's why we can deport them. That's why we are deporting them. Because they don't have allegiance to the United States. They are citizens of other countries. Um, uh, if a child is born to a parent who is a US citizen and another parent who is a citizen of another country, that child may be a dual citizen and has dual loyalty. The question is whether the United States asserts full control over that person when they're in our territory. If so, that's what the text of the Constitution means. And this allegiance theory doesn't work for yet another reason. In 1867, while the 14th Amendment was pending ratification in the States, there was a proposal to strip Confederate rebels of their citizenship. And the author of Section 1 of the 14th Amendment, John Bingham, said you can't do that because the 14th Amendment that we support, that we Republicans believe in, that's being out there for ratification, which codifies the 1866 Act and the common law in the United States, says if you were born in the United States, as these rebels were, and you're subject to the laws of the United States as they were, it doesn't matter whether they were disloyal or disallegiant. They repudiated their allegiance, but they were still citizens, and you can't take it away from them because allegiance is not a condition of citizenship. It's an obligation of citizenship. You're a citizen, and then you owe a fidelity, not you become a citizen by virtue of fidelity if you're born in the United States. Now, if you want to be naturalized, if you're not a citizen born here, then yes, you have to choose to become a citizen. But if you're born here, you're automatically a citizen, and being disloyal doesn't strip you of that citizenship because it's not a condition of citizenship. It's an entailment of the fact that you are a citizen. And that was voted down, and it never saw the light of day again. And everyone seemed to go their merry way and agree, okay, that's right. And that's why the court in Wong-Kim Ark said what it said. And I would rather be on the majority side of the Wong-Kim Ark than the minority. It was 6-2. And remember, this is a court that was not very progressive. This is the court that brought you Plessy versus Ferguson. And yet still, this was a lopsided decision in favor of the child of Chinese parents who themselves could never be citizens. Chinese who immigrated here could never become US citizens. But the court said, yeah, but the kid is automatically a citizen because he's born here.
Charles, did you want to address that? Or
Well, look, I only want to make the point that the key element of citizenship, again, was domicile and whether or not the individual whose child was born, whether their parents were domiciled. Obviously, a child does not decide its domicile. As the Supreme Court has said many times, a child is legally incapable of forming the requisite intent to establish a domicile. And so the child's domicile is determined by that of the parents. And it was clear under the common law as well as under the law of nations
Mm.
that it was the parents' status that determined the child with respect to domicile and with respect, obviously, to the allegiance protection reciprocal relationship.
I do want to introduce what is a common criticism of this sort of social compact argument about allegiance for protection, which I'm sure you've heard previously, which is, are we to believe that the founders of the 14th Amendment, just a few short years after fighting a brutal civil war to achieve the promise of the Declaration, would have advanced principles that would have led to perhaps a caste system of citizens and non-citizens, of um, l- loyal Union soldier citizens and uh, Confederate non-citizens? If the audience here tonight votes against the resolution, is that what they are supporting?
Not at all. The whole point was that being a permanent lawful resident, being domiciled in the United States was itself the basis for the protection by the sovereign and the allegiance which was owed in response and in consequence of that protection. And so that was the allegiance owed to the sovereign. It wasn't, and it flowed from the desire and the commitment to be a member of that body politic, our body politic. That allegiance was as a matter of law a function of that social compact, as you say.
Vikram, I see you wanting to get in
Yeah.
here.
So there is not a whit of evidence in the history of Section 1 of the 14th Amendment that this domicile concept was necessary to what it means to be in the United States or subject to its jurisdiction. We can't kind of engage a deep debate of the scholarship, but I commend you to read a lot of the stuff that Philip obviously took the time to read. Second, the English common law made clear, as the quote from Wong Kim Ark and the quote from the 1844 case from New York, that temporary sojourners are the children of those sojourners, of those visitors, are citizens if they are born in England or the United States, respectively. That's what it means to have a citizenship based on law of the soil rather than law of the blood. It's not the parents, it's the child, it's where he's born. And then third, there's not a single case that I've heard of, and if Chuck knows of one, he can tell me a single case of someone being denied citizenship in the aftermath of the 14th Amendment because he was born in the United States, but his parents were here only temporarily. They weren't permanent resident aliens. Again, you have to ask, well, what is this domiciliary concept about? It's about allegiance, Chuck says, but allegiance can't be the touchstone, both because the Confederate soldiers were not allegiant, and yet they were citizens, and their children were citizens. No one suggested otherwise. And because even permanent resident aliens who make their domicile here are still citizens of another country, and they have dual at best allegiance. They're not allegiant only to the United States. That's why we ship them out today until they become citizens. So the fork in the road is really this: either you can be a citizen only if you were born to citizen parents, as blood-based systems do in Europe, or a soil based system, you are a citizen if you are born here. That's England, that's us. And by the way, this provision of Section 1 of the 14th Amendment is not coming out of nowhere. Philip, you mentioned this. This is in keeping with the anti caste system and what it means to be an American. We have lots of provisions in the Constitution that say the Constitution is about who you are, not what clan you're born into. That's the Equal Protection Clause. That's Section 1 in birthright citizenship. That's the ban on on titles of nobility. We can't confer, dukes. No, and it's the prohibition on bills of attainder. All of those principles. The one principle that was inconsistent with all that was this quiet allowance of slavery, and we got rid of that in the 13th Amendment. Thank God. And once that was gone, this essence of the Constitution, that you're not bound by your parents. You are who you are, and you can make a life here. That's why the text of the Section 1 doesn't say born to parents, blah, blah, blah. It says persons born in the United States.
So
And subject to the jurisdiction
and
thereof.
so I want to put this question to you, Vikram,
Sure.
that has to do with common law as well as the social compact theory that Charles is advancing. I mean, I think it's pretty non-controversial that social compact theory is at the heart of the American system. The Declaration posits that governments derive their authority from the governed. We all know this. The Constitution talks about forming a more perfect union on behalf of we the people. And then we have examples of this in practice. For instance, the same year as the ratification of the 14th Amendment, the same Congress that passed the Civil Rights Act passed the Expatriation Act that states that any government effort which, quote, restricts, impairs, or questions the right of expatriation is hereby declared inconsistent with the fundamental principles of this government. So I know that's a long windup, but why is consent required to declare independence, to form a government, to go down any of the other avenues towards citizenship, and even to cast aside citizenship, something that was not possible under English common law? And yet, suddenly, in this one instance of birthright citizenship, consent is not required on behalf of the rest in the body politic.
Well, several points. First of all, consent as applied to a newborn child is kind of it's just a surreal concept. What does it mean to consent? You're born where you're born. That's one of the reasons that the birthright citizenship clause is written the way it is. We don't need to know anything about your parents. We just need to know where you were born. Can you imagine what the world would be like if we actually looked into who your parents were, your actual biological parents? Anthropologists suggest that 5 to 10% of people are not biologically the offspring of who they think they are. I mean, it's a terrible thing, but it's a reality. And so that's why Congress has passed laws, and after the 14th Amendment, if a baby was found, a foundling, a 2 week old baby, found in the middle of America, we don't know who the parents are, but we know that baby had to have been born in the United States because you couldn't get to the Canadian or Mexican border in the time the baby's been alive. That baby was a citizen. So yes, if you're going to become a naturalized citizen, you have to consent to that. If you're going to renounce your citizenship, you have to consent to that. But if you're born in the United States, you are a citizen by virtue of that. And in England, you are a subject by virtue of that. England doesn't let you leave being a subject. The adoption of the English common law in the United States is, as is true across all of law, is not jot for jot, tittle for tittle. We adapted the English common law to new situations here in the United States. But the idea that when we threw off England, and when we had a revolution that we had to base government on the consent of the governed, yeah, that makes total sense for adults. It doesn't make sense for children, which is why the 14th Amendment focuses on persons who are born.
Certainly,
Can I
the parents have agency in this situation, and perhaps you can take up that avenue, Charles. Here, I know you have a response.
Yeah, look, I think your question really brings into focus why it is simply not the case that this country adopted the common law jus soli and the rule of birth on the soil that Professor Amar is suggesting. It did not adopt it writ large. Uh, the fact of the matter is, the American Revolution and the Declaration of Independence clearly uh, uh, could not be reconciled with the proposition under common law that citizenship or subjectship in England was both perpetual and indissoluble. In other words, the subject in England could not, without the sovereign's permission, essentially, become anything other. It remained that person remained a subject perpetually, and was indissoluble. Uh, that was definitely not something that is the case in this country. As you pointed out, in 1870, the Congress gave voice to the fact that expatriation is a fundamental right of freedom. Now, I want to read a passage now also from the dissent, yes, in Wong Kim Ark. It's my opinion that Chief Justice Fuller and the sainted Justice Harlan, who wrote the perhaps most famous dissent in American judicial history in Plessy against Ferguson, were right in that case. And with respect to the uniformity of the common law, they said this: these considerations, this is after they go through much more than I was able to go through in the history of the citizenship clause, in their opinion. These considerations lead to the conclusion that the rule in respect of citizenship of the United States prior to the 14th Amendment differed from the English common law rule in vital particulars, and among others, in that it did not recognize allegiance as indelible, and in that it did not it, and in that it did recognize an essential difference between birth during temporary and birth during permanent residence. If children born in the United States were deemed presumptively and generally citizens, this was not so when they were born of aliens whose residence was merely temporary, either in fact or in point of law. So, two eminent jurists, and by the way, uh, you would think there's no scholarship at all on my side of this issue. That's hardly correct. There's deep scholarship, recent scholarship, particularly by Professor Lash, Professor Werman, Ilan Werman, Professor Shank, uh, 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 Randy Barnett, several very respected scholars have examined the record, and they have concluded that essentially the dissent in Wong Kim Ark was correct, or at least that the arguments on my side of tonight's resolution are reasonable and strong.
Vikram, I know that you've engaged with some of the arguments of those scholars that Charles just mentioned. I would like to get your response to what he just posited there.
So first of all, students often ask me, "Well, can't you argue this?" You can argue anything. We have to make one side has to be better than the other. The resolution is not can reasonable arguments be made on both sides. It's what the citizenship clause actually means, and you got to pick a side for that. So you got to decide which one makes more sense. Um, Justice Fuller was not a supporter of the Fourteenth Amendment. Okay, the dissenters in Wong Kim Ark, Fuller was not a supporter of the Fourteenth Amendment. I'd rather be on the side of Abraham Lincoln as Attorney General Bates before the 1866 Act and before the Section 1 was drafted. We saw the quote from that earlier. The 1844 case. So the idea that, yes, it's true that not every aspect of English common law was incorporated into the United States, but the birthright soil, the soil based birthright, even for sojourners, was part of what was brought in. Let me, I guess, pause there. Just leave it. As to the scholarship, it's really troubling to me. It's really problematic that a lot of people write scholarship only when we know what the consequences are going to be because we have some huge political dust up. I prefer scholarship that's written well in advance of what we know are going to be the partisan applications of it. So it's true that some folks have written recently, laying out arguments that they find creditable on the other side. Without being disrespectful, none of those are giants in the field like the ones I mentioned earlier. None of them is Mike McConnell. None of them is Akil Amar. None of them is Steve Calabrese. The reality is sometimes you have to pick and choose, just like Justice Fuller is not a well regarded Supreme Court justice. You can look at wiki him if you want to.
Is Justice Harlan?
Justice Harlan is, and everybody makes mistakes.
Yeah, I would.
Everybody, but look, it's 6-1. Yeah, you got John Harlan. And so yeah, I'm not saying that nobody could have said these things. I'm just saying the great weight of the evidence is to the contrary, and you got to pick one side.
Eh.
So there are scholars who are writing this stuff, but here's an analogy I would make. There was another big case a few years ago, um, called Moore versus Harper, involving the so-called independent state legislature theory, and I and a bunch of other people had written about this stuff 30 years ago before I had any idea how it was going to play out in politics. And a lot of people wrote a lot of stuff in the run up to this case. And when the Supreme Court looked at it carefully, it credited kind of the views of people who weren't really they were behind the veil of ignorance. John Rawls, a philosopher, said decisions that are made behind a veil of ignorance, where you don't know whether you're going to be helped or hurt by something, those are more credible. And I like scholarship that is more credible than mine. And I'll just leave this. If anyone wants to take a bet on how many votes on the Supreme Court will rule on the other side, I would give 10-1 odds there won't be more than one or two votes.
I will not be collecting any side bets this evening. We're not set up for that kind of activity or
Well,
action.
there's
You're gonna
all
get
these
me in trouble
prediction
here.
markets. There's Polymarket and Predict It.
Okay.
If you go on those and you can get odds that are better, go.
But
For it.
I do have.
But I would like, if I
Yeah.
may, Mr. Moderator, just to say this: rather than test the credibility of the arguments by the uh, ancestry of when they were written, or by the respectability, at least in Professor Amar's judgment, of either the justice or the scholar, read the scholarship itself and judge for yourself.
We agree on that. That much we can totally agree on.
That's what I
read
ask.
Mike Ramsey's piece in Georgetown Law Journal, which is the best.
Well, I commend both of the writings of these gentlemen. They both have engaged with it. I do have a question, which is clearly an appeal to authority, and it's about the democratic process. My question here is, if the consensus view of the 14th Amendment is correct, and the children of parents here illegally our citizens. Vikram, are you not denying members of the body politic the ability to decide who is in the body politic? In other words, if the audience votes for the resolution, are they not voting for their own disenfranchisement?
No, they're not, because we can change. If we don't like the rules, we can change them. That you said we're not disenfranchising ourselves. We're not divesting ourselves of that. If you want to change the 14th Amendment, I'm actually open to those arguments. I think there are actually a lot of other things you could do short of that. I'm not a fan of kind of birth tourism and the like, but you could, for example, if someone's here unlawfully and their kid is born here, you can ban those parents from ever becoming citizens. You can also, of course, deport them, which means that the child has to go away, most likely until she's 18, because she's got to go where her parents are when she's young. There's lots of things you can do to discourage. You can control the borders in a way that Joe Biden didn't do, and I'm glad Donald Trump is doing. There's lots of things you can do, and if at the end of the day you don't like those things, then you can talk about amending the Constitution. But all of that is about policy, not about what the law is. You know, conservatives were really critical of Roe versus Wade. I worked for Justice Blackmun 3 decades after Roe, and I readily admit that Roe was made up. Maybe there are other ways to get to that result, but the way Roe versus Wade was written was not grounded in the Constitution. Well, that's fine. If you want to say in Dobbs, you can't make stuff up, great. But then you can't make stuff up on the other side either.
Yeah. And Roe versus Wade, what was the score in that case?
7-2.
7-2. Okay. 72.
Yeah.
But they were wrong, weren't they?
Yeah.
So the head count doesn't always mean that the dissent was wrong, but we have stumbled into some agreement here because, yes, if Professor Amar, my friend, my respected colleague, is right with respect to the resolution, then yes, the people are disenfranchised. They cannot change that result unless they can form majorities large enough to amend the Constitution.
This is, I think, perhaps a clarifying question, and forgive me if I should have asked this earlier, but as both of you see it, let's just ask a practical question. Could the president just overturn the previous understanding of birthright citizenship unilaterally by executive order, or would it be necessary for Congress to act by statute to overturn it? I guess what I'm trying to get at here is from Wong Kim Ark to Elk versus Wilkins in the current case law. And I don't read law, in case you don't know, just a journalist. But as things stand currently, would there be something else necessary to overturn this? Charles, would there be something additional?
Listen, I'll be brutally frank. I haven't studied that question. I do not know if a congressional enactment would be necessary to essentially affirm what President Trump has done. I do know that the State Department and the executive branch has been responsible largely for the interpretation of the citizenship clause. We haven't had any case. Uh, Actually, I take it back. There is a case called Elk, which I believe was really adopted my view of the resolution. But we haven't had a case that has squarely addressed these questions, let alone whether or not Congress is a necessary ingredient. But we do know that Congress has enacted a statute that is essentially the same wording as the citizenship clause. So there's a different question whether or not that statute has any force quite apart from the clause itself.
Vikram, could you take that up? But then
Yeah.
also, Charles raised Elk versus Wilkins. I don't know if that's an instructive example here.
Elk versus Wilkins is completely irrelevant. Elk versus Wilkins involved an Indian who was born on the reservation and was not a natural born citizen who wanted to become a naturalized citizen. And it's about the process for allowing him to become a naturalized citizen, whether he had that route available to him. But there was no question, nobody in the case thought there was any argument that John Elk had to be a natural born citizen. He was born to Indian sovereignty on Indian land. He was not born in the United States, not subject to the jurisdiction thereof. It's not a case that's relevant at all, really. So, on this question of whether Congress would have to act, I think the answer is yes. In 1952, Congress passed a statute whose words do track Section 1 and whose meaning, I think, best understood as a statutory matter is it adopted the understanding of Wong Kim Ark. So, for before this executive order would have to go into effect, the court would have to agree that all of the history I mentioned was wrong. That the fact that no sojourners' children were ever denied citizenship in the wake of the Civil War and the 14th Amendment is just a bizarre dog that didn't bark, but that they were out there and we just didn't know. And that the Supreme Court itself was wrong in Wong Kim Ark, and that Congress doesn't have the power to codify Wong Kim Ark as it did in 1952. You have to agree with all of that before it credits this particular executive order. And then on top of that, by the way, and this is an important point, the executive order, again, decitizenizes people who were born in the United States to parents who are either here unlawfully or temporarily. Millions upon millions of people whose parents were here temporarily, who have been considered citizens for forever, for 30, 40, 50, 60 years, those people technically would not be citizens. Now, the executive order says we're going to apply this only prospectively, but that's just a matter of grace. They don't say those people are citizens. They just say we're not going to apply the definition of citizenship. We're not going to disrupt the past. We're just going to do this going forward. But there's no reason why they couldn't disrupt the past if, in fact, those people aren't citizens and we've wrongly considered them citizens.
Well, I was so there's. Do you think that these three exceptions are a close set of aliens, Native Americans, and invading armies? Certainly, it has narrowed. We no longer after the
Indians, we don't worry
Indians.
about.
That's no longer there.
Yeah.
But if it can be diminished, can it be expanded?
No, that's the nature of a right. Oh,
Look, the fact that Indians were added to the exceptions it shows that the common law wasn't the closed set. It was there was nothing in the common law about American Indians and whether or not they and their offspring would be citizens. And it was very clear from the debates in the 14th Amendment, as I said earlier, that they drew a distinction between Indians, you know, based upon their allegiance. If Indians had left the reservation, an Indian who left the reservation and domiciled in what they called the white and civilized settlements, uh, uh, and had a child, that child was a citizen, according to the founders. Why is that? Because uh, the Indian had left the foreign power and had joined the body politic of the American people, and that was the key element. Had exchanged again allegiance to the United States, had abandoned allegiance to the tribe, the foreign power, had committed himself to allegiance to the United States, and received the protection of the United States. That there was nothing in the common law that prescribed that. That was a result of of this of the citizenship clause and their understanding of the citizenship clause in the 39th Congress.
Vikram,
Yeah,
get
so
in.
Philip, you asked whether you could add exception, add new categories. Yeah, you could add them before you adopt the 14th Amendment. You can add them in the 1866 Act, and you can add them as the understanding of the backdrop of the 14th Amendment. You can't add them afterward. That's the nature of a right. Once you enact it, the right is protected. Let's go back to this allegiance thing once again. Allegiance can't be the key because the Confederates were not loyal, they were not allegiant, and the drafters of the Section 1 said they're still citizens and you can't do anything about that because they're born in the United States and they're subject to the power thereof. Permanent resident aliens have allegiance to the country in which they are citizens. They are still citizens of those other countries that we send them back to. So allegiance cannot be the key to understanding subject to the jurisdiction thereof. It just doesn't work with the history, both pre and post 14th Amendment.
It was clear that the that the allegiance of the individual was owed to the protection of the sovereign where that individual made his domicile. And if he had a lawful permanent residence in our country, that was the allegiance. The individual received the protection of the sovereign, including the consular protection when that individual was traveling abroad. So the allegiance owed to the whether it be the tribal foreign power or the foreign power abroad was abandoned, and a new allegiance was formed when the individual joined a new and different body politic, ours.
I want to get to some of the audience questions here. One for you, Charles. Someone asks, how can the negative argue against all Americans being foreign on alien land when it was the U.S. first taking over native land? I don't know if that is outside of the scope of your argument, but it seems to be an interesting challenge.
Yeah, I think that is outside the scope
Right. Again, we
of my
agree on
point.
There we go.
My
This
point.
is your
I,
reminder to send as many questions my way as you would like. I'm
but
populating this right now.
I do think it's premised on what was at least the reality that the 39th Congress was dealing with, which was they viewed the Indian tribes as foreign powers, as quasi foreign nations, and it was only when an Indian uh, uh, transferred that allegiance from the tribe to the United States that that Indian's child then would become a citizen. And one of the interesting passages from the 39th Congress debate was the explanation for why they dropped excluding Indians not taxed. They dropped that because they were afraid Trumbull, who had authored that language in the 1866 Civil Rights Act, but he changed his mind about it because there was too much risk and concern that that would place a wealth-based test standard for citizenship of Indians who had abandoned their tribe, their foreign power, and who had become allegiant to the United States. And he said, I am not willing to have the rich Indian domiciled and residing in New York become a citizen, but the poor Indian residing in New York not become a citizen. So it was very clear that when the individual Indian left the foreign power, came into this into the American body politic, that they brought themselves within the citizenship clause by virtue of that allegiance, the change in allegiance.
We're back to Indians non-tax. Vikram, would you like to respond to anything we heard from Charles just there?
Well, again, Indians are not subject to the jurisdiction of the United States because the United States doesn't try to apply their law to them. It's like a foreign nation that's within our midst. That's what the reservations were considered until we got rid of them and altered our relationship with Native American tribes. The exceptions to the 14th Amendment's general command that if you're born here, you're a citizen, namely ambassadors and their families, the Native Americans, and children born to occupy in areas that are occupied by foreign armies, which we haven't had. All of them are focused on whether American law applies to those people or not. It doesn't apply to Native Americans. It doesn't apply. We have diplomatic immunity that exempts families of diplomats from American law. We have immunities that exempt Native Americans from American law. In areas that are occupied by foreign armies, those armies are the law that governs, not the United States, if we were to be so unfortunate as to have those. All of those are about whether American law applies. But there's no doubt that American law applies to children born here to parents who are here temporarily or illegal. I mean, if your parents are here unlawfully, that doesn't give you a free pass to violate all the laws. If your parents are here on a vacation, you can't flout American laws. You are subject to the power of American laws, regardless of allegiance. You are within the jurisdiction. You are subject to the jurisdiction. That's what the amendment says. That's what it was understood to do. I'll come back to this again in the closing, but give me examples of people after the 14th Amendment who were not considered citizens, but the United States did not consider them citizens, even though they were born here and they weren't Native Americans and they weren't diplomats. Who are these people? Why are there none of those that we have examples of?
There are examples. There are examples. I'm not sure about examples of what you're suggesting. I honestly
So what's
just
an
don't know the
example of?
answer to that, but there are examples of children born on the soil of the United States that were not viewed as citizens and were not accorded American citizenship by our government. The scholarship recently of Professor Estreicher identifies several of those situations. But I want to come back, if I may.
No, not to people who weren't Indians or diplomats.
Well, I think you're referring to some of the examples post-Revolutionary War where loyalists moved back to Great Britain and their children who were born here. Obviously, all of this is before.
The 18th and 14th
No,
Amendment?
no,
Yeah.
no,
Is that's not what you're referring to?
no. I'm referring to post 14th Amendment examples of State Department activity.
Okay.
Uh, but this exchange brings me back at least to the Elk case. That case it did involve a Indian born on the reservation to tribal parents in a context where obviously uh, that newborn uh, was not subject to the complete or any of the jurisdiction of the United States. The allegiance that newborn came into life with was his parents' allegiance to the tribe. But that individual, Mr. Elk, had left the tribe. He had come into the United States. He was domiciled. He had entered American society, and his allegiance had transferred to American society. And but because he was born uh, in a tribal circumstance, the court said no, he's not a citizen. But it did speak to the question of what was the test under the citizenship clause. It says the evident meaning of. I want to share this passage with you. The evident meaning of the subject to the jurisdiction thereof is not merely subject in some respect or degree to the jurisdiction of the United States. And I add as a side, subject only to the obedience to the laws of the United States, but completely subject to their political jurisdiction and owing them direct and immediate allegiance. And what determined whether or not an individual owed that direct and immediate allegiance? A person born in the United States is completely subject to its political jurisdiction if he has severed his relation to his home country and fully and completely surrendered himself to the jurisdiction of the United States and still continues to be subject to the jurisdiction of the United States and is a bona fide resident thereof. If John Elk children, their citizenship was questioned, there's no doubt they would have been citizens because he had domiciled himself in the United States. His allegiance was no longer to the tribe, it was to the United States, and he was completely subject to its jurisdiction. This was the first time that the Supreme Court interpreted the 14th Amendment or the Citizenship Clause after its enactment.
Why is Elk not instructive here?
Because again, John Elk was born on a reservation, and there was no claim that he was a natural born citizen. He wanted to become a naturalized citizen, and the court was wrong to deny him that. I mean, it's a bad case, but the court said you can't even become a naturalized citizen. That may have been right or wrong. I think it was wrong, but it had nothing to do with the part of the 14th Amendment we're talking about, what it means to be born a citizen, not become a citizen if you are trying to come from an Indian sovereign or another country. It's just beside the point. And again, this idea that citizenship requires complete jurisdiction. Well, persons born here to parents who are temporarily or illegal here are subject to the United States complete jurisdiction. There's no United States law that they can violate with impunity. As far as I know, they don't have any immunity. They're completely subject to our power. We can punish them, as John Marshall, Chief Justice John Marshall said in 1812. They are subject to the laws of the United States. And finally, again, permanent resident aliens, whom everyone seems to agree have children here, born here, are citizens. Those permanent resident aliens have not severed their ties with their home countries. They live here, to be sure, but they're still citizens of those countries. They're not a citizen of the United States. They're a citizen of those countries. So that all these efforts to get around the text of the amendment, they just can't work as a logical or a kind of a historical factual matter.
A member of the audience asks this question of you, Vikram.
Sure.
If allegiance doesn't matter, why are newborn children of diplomats excluded? And I think that this generally gets to this question of, if subject to the jurisdiction thereof is only those three exemptions, why not name them? Is it just fancy window dressing?
No, because well, it's actually not just three. There are others that are less common. So, for example, if you're born on a foreign warship, okay, in
How could I
U.S.
forget?
U.S. waters, you're not subject to jurisdiction because we don't consider that part of the United States. That's why I used the term earlier. If you're born under the American flag. So just that's an easy way to look. Is American flag kind of in the background? It's not in a Native American reservation. It's not in an embassy. It's not on a foreign warship, and it's not in an occupied territory. So that's the key. Is what was the original question from the audience again?
It had to do with the
Why?
children
Yes.
of
Again,
ambassadors, the why.
the why is not because they're not allegiant, it's because we don't apply our law to them. We recognize it's it's as if the embassy is a floating part of another country. It's another country that we're giving space here to. And if you're born not in the embassy but in a hospital a block away, it's the same because we don't want to create incentives for people to have to be born in on the reservation rather than the hospital, or in the embassy rather than at the hospital. It's that this is why, by the way, when the Iran attacked our embassy in 1979, that was such a big deal because that was American soil. But the embassies of foreign countries in the United States are not part of the United States in the sense that we don't subject them to our laws.
I have a number of questions here that have to get down to the basic fairness of things, of justice.
Right.
Um,
I'm sorry.
yes,
May I just respond
of
to
course.
that? There's just no question that obviously ambassadors and other foreign ministers were not the only people who were exempt, if you will, from the foreign from the proposition that uh, subject to any foreign power in the 1866 Act. That language encompassed anybody subject to a foreign power, not just ambassadors, not just uh, foreign public ships, troops on foreign public ships. And the others, it clearly, on its face, encompassed anyone subject to a foreign power. And that meaning of that phrasing was not changed when it was
Yeah.
changed to subject to the jurisdiction
And, and,
thereof.
and the 1866 Act says subject to foreign power it meant subject exclusively to a foreign power. Again, permanent resident aliens are subject to foreign power. And everybody agrees they're covered under the 66 Act and their Section 1. It's not about whether another country might claim you. It's about whether we consider you fully regulable. If we do, you are subject to our jurisdiction and you're covered by the 14th Amendment.
I want to make certain that we have time for closing arguments, but
Sure.
just exercising my prerogative here as the moderator, I think that this final question will perhaps bring us home and put a bow on things. And it has to do with the fundamental question of justice and the type of regime that we inhabit. So I guess final word here goes to Supreme Court Justice Louis Brandeis, who observed that, quote, the only title in our democracy superior to that of president is the title of citizen. I'd like both of you, one at a time, to reflect in our final moments here on what your interpretations of the 14th Amendment necessarily means about the nature of our country. Uh, you can start, Vikram.
Sure. Well, again, as I said before, I think the citizenship clause of Section 1, the birthright citizenship clause of Section 1, is not only kind of historically building on the adoption of British notions of territorial citizenship and the like, but it's in the grand tradition of the Constitution as a whole that we don't care what your family was into which you were born. We're going to judge you based on who you are. That's why we don't have titles of nobility. That's why we don't have bills of attainder. That's why we have an equal protection clause that protects against racial discrimination and racial preferences and religious discrimination under the First and 14th Amendment and the like. So I actually think this is not just a technical question of, well, how do we treat a few several million people, I guess. But it really does go, as you said in your introduction, to what American constitutionalism is about. And again, I'm not saying it, like, if we have a problem because the Constitution is being abused, as we've had a problem in a lot of areas of constitutional rights where the original framework is abused, then we can fix that. We can amend the Constitution and the like. But I don't think we should be departing from the words of the document and the history of the document and the practice of the document um, uh, just because we find ourselves not liking some of what's going on today.
Charles, on the value
Yeah.
of citizenship for your side of the resolution.
Well, look, I agree with much of what has just been said by Professor Amar. This country welcomes all, regardless of race, regardless of creed, regardless of origin, regardless of color. Uh, but it welcomes them into the body politic if that is what they want to be part of the body politic, part as Harlan put it, simply part of the people of the United States, as in we the people. But that's a far cry from whether or not people who have come into the country in violation of our laws, or people have come into the country for one purpose and one purpose only, and that is to provide birthright citizenship to their child from a foreign land and then leave. Those are that is not what the citizenship clause contemplates, and not what the values underlying the citizenship clause contemplate.
Uh, we've reached the portion of the debate for closing statements. I want to remind you, as the audience right now, that once again, the QR code that you used to vote initially, that you used to send in some of these questions, that poll is now open once again. Please register your vote now. And, Vikram, we'll start with you. If you like the podium to make your final
I
remarks,
could have,
or stay here. Yeah, yeah.
yeah, I'll stay here. It's easy. Um, so again, the words of the 14th Amendment focus on the person who is born, where that person is born, and whether that person is subject to the United States power. It doesn't focus on the parents at all. We do not visit the sins of the parents on the children under Section 1 of the 14th Amendment. It's pretty much as straightforward as that. I understand that there are incentive problems created when we are so generous in our constitution, and maybe we should punish the parents who come here unlawfully or who come here to give birth to a child. We should deny them citizenship possibility forever, or we should amend the constitution altogether. But we can't kind of just get around what the constitution says, what the Republicans who adopted the constitution. A lot of the arguments that my esteemed colleague advances were made by people who opposed the 14th Amendment. They're the people, they're the Democrats. They're not the Republicans. They're not the party of Lincoln at the time. They're not the people who embraced what happened after the Civil War. And I think in general, if you look at what the Republicans, what Bingham said, what Bates said, and the like, that this is a pretty unbroken string that follows the text of the Constitution and that incorporates this idea from England. Allegiance can't be the key because that doesn't account for permanent resident aliens. It doesn't account for the Confederate rebels who were not allegiant, who remained citizens. Illegality can't be the key because, as you pointed out, Philip, a lot of children born to slaves who everyone agrees were made citizens by Section 1 of the 14th Amendment to repudiate Dred Scott. Um, a lot of those parents were brought here and were illegally present here, even after the ban on slave importation in 1808. It was widely known, it was notorious that there were thousands and tens of thousands of enslaved persons who were here illegally because they had been brought in violation of federal law. And yet those children were nonetheless fully welcomed as citizens when they were born here, even though their parents weren't. The parents who were brought here illegally needed a naturalization act to become citizens. They weren't natural born citizens, but the children were because they were born here and subject to our laws. So let me close by reminding you of the text of the 14th Amendment and basically highlighting what the other side really wants the text to say, but it doesn't. It says all persons born in the United States and subject to the jurisdiction thereof are citizens. Okay? The other side wants to read it all persons born in the United States to parents who, by acts of allegiance and permanent residence, have become subject to the jurisdiction of the United States are citizens. And if we want to add those words, let's go through a process. But you can't just jam them into a document that doesn't have them. And although the words subject to their jurisdiction has to be interpreted, we agree on that. I just don't think the interpretation offered under any of these alternative theories of allegiance or illegality or ephemerality as opposed to permanence, none of them explains the history, the post 14th Amendment practice. As I say, I keep saying, give me examples of people who were denied citizenship, who were born here, who weren't born into an embassy family or on a reservation or on a foreign flag, a foreign worship or the like. There aren't any. Sam Estrecker, I'll go back and read his article, but I'd be very shocked if he has any that really fall outside of these well-known examples. It's not until Wong Kim Ark that the United States even tries to impose a different understanding, and they're repudiated by a court that was not a big fan of reading the 14th Amendment broadly, and yet even they saw that the words mean what they mean, and the common law of England applies to this limited extent. And so when push comes to shove, I'm not saying that the arguments on the other side are frivolous. I would never say that about anything my friend says. But I just don't think they remotely rise to the level of being the best arguments. And in all of constitutional law, question isn't, well, you know, is that argument free from any kind of problem? No, it's what's the best interpretation. We got to pick one, and the one that's been time honored, I think, is the one that will continue to be embraced. And I like it because it coheres with the words and the history pretty darn tightly.
Thank you, Charles.
Well, thank you once again, ladies and gentlemen. I want to thank once again our organizers and my colleagues here on the dais. I can be brief. It is true, of course, that in this country we do not visit the sins of the parents on the children, but neither do we reward the children for the sins of the parents. And when the aliens who are here either illegally or temporarily, and their child is born, at least under the new executive order, if it is valid, uh, they will not be natural born citizens. And if that is a punishment because they are the citizens of whatever country they came from, their parents came from, then that is a punishment that isn't visited upon them by the people of of the United States. It's visited upon them by the parents who came here illegally. And I do think that Professor Amar's framing of what the citizenship clause, if you were going to write it out, uh, is pretty accurate. It's pretty accurate for what the citizenship clause means, at least what subject to the jurisdiction thereof means. Again, the the that wording is the direct descendant of not subject to any foreign power in the 1866 Civil Rights Act. Wording that its author said straight up does not was not intended to include the children of those here temporarily. Said it straight up. And then in the 14th Amendment said again that nothing in the scope of the 1866 citizenship provision was intended to be changed. They just changed the language to capture the same scope. And what was all the uh, uh, discussion and conversation in that debate about allegiance? What did it mean to say the purpose of this clause is to ensure that everyone with allegiance to the United States, born in the United States, would be a citizen? And why did they debate at such length and in such detail over the fact that Indians, subject to a foreign power, their tribes and their children, whether they were born on the reservation or whether they were born on a sojourn by the parents off the reservation temporarily, uh, they would not be entitled to citizenship. But the Indians who left their foreign power, who embraced a commitment to become part of the American people and to uh, transfer their allegiance from their former tribal sovereign to the American sovereign, a- and that their children, whether rich or poor, would be citizens under that clause. All of that, and 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 the that clearly applies to other foreign sovereigns, not just tribal foreign sovereigns. So I come back to this. Read the debates yourselves. Read the debate yourself and see if you think that subject to the jurisdiction thereof, does not at its core require this notion of allegiance and the reciprocal relationship between the sovereign who affords protection to the individual and the individual who in return provides allegiance to the sovereign. So again, I thank you for this evening. It's been a lot of fun, and I have to say it. Roll Tide.
Self-inflicted wound.
That's going to cost me some votes. I know that.
Well, I noticed that both of our debaters were nodding their heads at Charles' suggestion to go back and read the debates. And with that, our debate this evening concludes. We do have the results, which should be showing up behind me shortly. Initially, as it began, 71% agreed with the resolution. At the end of the debate, 77% agree with the resolution. So agree moved the dial by 7 points, and disagree lost 2 points. And that is based off my quick math. I can't quite think that's accurate, but I'm sure someone will fact check me if I'm wrong.
Thank you. Please join me in thanking our speakers.
Always a pleasure.
I have just a couple of brief closing remarks and reminders. I want to thank our sponsors again and our donors who make events like this possible: the Arthur and Root Foundation, the Adolph Horst Foundation, the Diana Davis Spencer Foundation, the Linda and Harry Bradley Foundation, the Jack Roth Charitable Foundation, the Tina Snyder Foundation, and Bruce and Marcy Benson. I also want to say a special thank you to the Institute of American Civics, to Josh for helping me plan this event. I'm so happy that it happened. And I want to thank each of you, members of our audience, for showing up tonight. Your dedication to the cause of civil discourse and the free exchange of ideas is noteworthy. And I encourage you to also join our mailing list with the Steamboat Institute. Follow us on YouTube so that you can catch more great events like this in the future. And I thank you again for coming out tonight. Have a great evening.